for a mere 705 crores. And may not take a nauseous permission to hand over a small chart.
What is the name of the building?
Palaise Royale, right?
What is that?
Palaise Royale. P-A-L-A-I-S-E, Palaise Royale. I do not know how to pronounce it properly. Just this person. Yes. Yes. Yeah, okay. And my lord, the chart can explain things, my lord, very lucidly in the fewest of words. It's just like a photo. Summary of the flow chart of rotation of funds of Indiabulls Housing Finance Limited. My lord, Indiabulls Group of Samir Donat. It has two companies. One is Indiabulls Real Estate Fund. That is on the left side. The other is Indiabulls Housing Finance. On 24th of June 2019, an amount of 330 crores was transferred from Indiabulls Estate Fund to Ashton Township in the form of two accounts. One is, my lord, CROCD means credit, cash credit. These stands for cash credit, OCD, overdraft cash credit, yes. And the other is CCD, okay, that is electron, yes. And the terminology is a banking terminology, yes. Now, then, my lord, to another company, Ashton Developers, 250 on 25/6 next day, 440 crore was transferred in two tenders, 135 crore as CROCD and 285 crore as CCD. Then, my lord, on the very same day, these two companies.
No, wait 1 second. Then this developers.
One
second. Developers transferred 44 crores.
No.
Developers to township.
Yes. The Ashton Township and Ashton Developers, they transferred.
Developers has transferred 44 crores.
No. There's an intertransfer also. Yes, there's an intertransfer also. Yes. And then these two companies transferred to owner shelters a total amount of rupees 747 crores, of which 42 crores is registration charges. And the same money on the very same day, because 372 crore was received only on 25/6/2019. On the very same day, the money was transferred to Indiabulls Housing Finance. Now, my lord, may take your lordship to the.
No, who is the purchaser? This
ownership
fund or housing finance?
Indiabulls Housing Finance is a seller, which has taken possession of the property under the SARFAESI Act.
So he is a buyer, not seller.
No, owner shelter is the buyer. The owner shelter private limited is the buyer, and the owner shelter private limited has 1 lakh rupees of capital. Zero revenue, zero operation.
130 is fine.
Yes, a shell company purchased a property, but my client says 10,000 crores. Let it be 5,000 crores. Let it be 2,000, whatever it is.
Let us be clear on facts. When you say this, when these funds came to housing finance,
on the same day,
Right, on the same.
On the same day.
Why are you stressing? Then what happens thereafter?
Then, my lord, this money was utilized by the owner shelters to buy the Palaise Royale apartments under a auction conducted under the SARFAESI Act.
Yes. So on the next page.
Yes. So therefore, my lord, the all money came from Indiabulls.
No.
There's nothing in his pleadings about this. How do we?
No. The pleading is I take your lordship, take your lordship to the pleadings. Page 35. Page 35. I will read it, my lord. Yes. My friend has any problem, I read it out. Yes. At page 35. Page 35. Page 35 of my petition. F. The petitioner states. The lordship of my lord, page 35. The petitioner states that as part of the scheme of fraud, page 35, my lord, my petition. The petitioner states that as part of the scheme of fraud, HSPL, that is Honor Shelters Private Limited, a shell company with zero capital, being a shell company without having any capital asset, was shown to have secured loans from 4 companies as detailed below. Ashdan Developers 372 crores, Ashdan Township Ventures 375 crores, Chotia Holdings and Construction Private Limited 130 crores, Mittal Brothers 1.28 crores. But these other two, we are not primarily concerned because we are concerned about the sale by Indiabulls of the property which to possess under the SARFAESI Act to its own shell company. Now there's a pleading. Now I read further down, my lord. The listed entities have received funds from Indiabulls Group and in turn funded the Honor Shelters Private Limited to purchase a secured asset mortgaged by the Sree Ram Infrastructure Limited, that is SRUL, to Indiabulls Housing Finance Limited. Thus, the purchase of the secured asset in the auction by Honor Shelters Private Limited was indirectly funded by the Indiabulls. Honor Shelters Private Limited perpetuated the sham transaction by executing a deed of hypothecation in respect of 58 flats out of the total number of 162 flats in the Palaise Royale building in respect of the 2 loans allegedly taken by HSPL totaling rupees 572 crores by appointing Beacon Trusteeship Limited as a security trustee under a deed of hypothecation agreement dated 11/11/2020, which petitioner has access from the MCA website. It is pertinent to point out that the sham deed of hypothecation only names the borrower HSPL and the security trustee, Beacon Trusteeship Limited, but does not disclose the lender's name from whom HSPL is said to have borrowed the aforesaid sum of 572 crores. The said agreement also names a certain Hidesh Agrawal as associate as an agent of the lender without any reference to the identity of the lender and such lender's address. The above mentioned agreement and its signatories ought to be thoroughly investigated to trace the antecedents of the unknown lenders as well as funds that have moved between the parties as a consequence of this agreement. Well, it is pertinent to point out that SRUA, that is Sree Ram Infrastructure, was a respondent in the public interest litigation filed by Janhid Manch, an NGO which challenged this action to the public working plot under PA 43 of 2012. Sree Ram Infrastructure had pursuant to the sanctions and permissions constructed a public parking for 900 parkings in an independent building consisting of 3 basement plus ground plus 15 upper floors on a portion of land about 4,200 square meters and subplot 5B plus 6 after obtaining necessary building permission. CREL had reportedly incurred a cost of 165 crores to construct the public building. This was the incentive for the FSI of 31,000 etc. square meters, and the value of the FSI as per then ready reckoner was 446 crores. The official number of this now using this PIL, an order came to be obtained from this honorable court staying the operation of staying the construction. An order was passed in the PIL staying the construction of the further construction of the building, and that led to Malati. I was a supplier of steel to the Sree Ram Infrastructure, and thereafter the company failed to pay me, and leading the scenario where I left with no option than to file a suit. I obtained a decree, and that decree, I as an MSME is entitled to primacy over all other creditors. 2026.
Sir, आएंगे ना?
Yes. SARFAESI Act. I take your lordship to 26B. 26E, yes, 26E of the SARFAESI Act. 26, no, not 26, I made a mistake, 26E. SARFAESI Act. Yes. I obtained a decree in the year my decree was here. I obtained a decree in 2015. 111, yes. Yes, 111, my lord, yes. My decree is dated 7/10/2015. May I take your lordship to page 101? 111. Exhibit B. As you pay 112, the decree is, the suit is decreed in terms of prayer clause A. And the 26E came to be incorporated only in 2016, and which came with effect from 1/9/2016. May I read, my lord, 26E? Priority to... 26E. Priority to secure creditors. Notwithstanding anything contained in any other law for the time being in force, after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts, and all revenues, taxes, cess, and other rates payable to the central government or the state government or local authority. And before this amendment came, in terms of Chapter 4 of the MSME Act, MSME Act, yeah, not what? MSME Act. MSME Act. Yes. May I take your lordship to Chapter 4? Chapter 4, man. Only one or two sentences only read. Chapter 4,
Madam.
Section 16, page 11. Only one or two sentences here and there I will only read, my lord. Oh, sorry, I made a mistake. Chapter 5. Sorry, my lord. Section 16, last sentence. As the case may be, from the date immediately following the agreed date, at 3 times of the bank rate notified by the central government. Then under section 17, my lord, I can approach the MSME council. And my lord, under section 19, say application for setting aside the decree, award or order. No application, etc. shall be entertained unless 75% is pre-deposited.
What is the point?
The point is, my lord, I as an MSME had a primacy priority of the claim of the Indiabulls housing finance. So my liability, my decree has to be satisfied first. My grievance is, I am out. I didn't get a single pie. The entire structure was taken possession by them. And that is the reason why I am interested in inquiry into the crime. The offense, yes? That is, I am not a busybody. I am here because I have an interest to protect. That's why the last day also I made an offer. If you are willing to honestly pay my money, then I am willing to settle the matter. Now, this is the background. Now, I take your lordship to the chart. The entire money which was paid was returned to the Indiabulls real estate. Next page, my lord. The money which was funded, forwarded to the Indiabulls real estate, Chotia, etc., was repaid to the Indiabulls real estate. So, sham transaction. May I take your lordship next page? This chart. Indiabulls real estate fund. The second is Indiabulls housing finance. Indiabulls housing finance repays 976 crores. This money goes to Chotia. And in turn from there it goes to owner shelters. And from them it goes to Assam Township and national developers. And then goes to the Indiabulls real estate fund. So the money is a sham transaction. It is a
Most of the entity of Indiabulls real estate fund, there is no such party in this picture. There are 46 respondents for no Indiabulls real estate fund. There is no such entity at all.
I'll take you.
I just don't know.
Yes. I'm taking it. See, I'm a complainant. I'm not an investigating officer to get everything the material with accurate. No.
File this petition as a blackmail act.
No, my lord, at page 3, respond number 11, Ashtan Developers Private Limited. Respond number 12, Ashtan Township Ventures Private Limited. Respond number 13, Adil Chotia. Respond number 14, Mr. Builders. Respond number 15, Indiabulls Finance Limited. Respond number 16, Owner Shelters Limited.
We have understood your grievance.
So now, therefore, my lord, now, this I am only saying, my lord, I am a complainant. I am only asking investigation. If the investigation, if the investigation would disclose that there is no offense, I am only asking the investigation, not a conviction.
Good, I just quickly in a nutshell.
Your thought?
I am for Indiabulls Housing Finance. We are in India. it is our job to give loan. We have given a loan, and that is about us. We have been repaid. Honest Shelters has taken a loan and repaid. Now, Malak, what had happened was that SRUIL, who was building Palaise Royale, went into bankruptcy. They defaulted on the mortgages given by me. As a result of which, under the SARFAESI Act, I enforced those mortgages and I started a winding up procedure as well as gone to the NCLT.
But he has a degree. His grievances,
Yes.
besides all those allegations that
Yes.
funds were
Yes.
transferred,
He has a degree.
signed from.
He has a
He
degree,
has
but
a
what he
degree.
doesn't point out to your lordship, what he doesn't point out to your lordship is that with this degree he has gone to the NCLT and he has made a claim. Out of his 30 crores, 17 has been accepted, 14 is under investigation. That is not pointing out to your lordship.
But he had said about the NCLT proceedings.
No, he has not pointed out that he has made an application there in which
That paragraph K, page 37, he had stated about some section 7 petition and company appeal.
your lordship is reading page
37.
Yes. Lordship, just give me a minute.
Page 37.
37, my lord, your lordship is reading. SRUL was admitted into corporate insolvency under an order passed on 6/11/2019 on a Section 7 petition filed by SREI Infrastructure Finance Limited. The order was challenged by Action Barker in a company appeal before the NCLAT on the ground that since Section 7 petition was filed against IHFL and SRUIL was dismissed, there was no occasion for the NCLT Mumbai bench to admit a subsequent Section 7 petition by SREIL. However, the NCLAT dismissed the appeal of Action Barker and confirmed the order of the NCLT, admitting Section 7 petition against SRUIL. The petitioner filed civil appeal against the NCLAT order confirming the admission of Section 7 by the NCLT Mumbai. The Supreme Court by its order dismissed his appeal. So he went from the NCLAT order, he filed an appeal to the Supreme Court which is dismissed and confirmed the order of the NCLAT. The petitioner then filed a review petition before the Supreme Court, seeking review of the order.
We were responding to that he had suppressed. No, he had disclosed it.
No.
That is another.
No, this is something else. Yes.
All right, we'll hear you. Please wait 2 minutes.
No, he's for honest gentleman.
I am the party who is very like compared to I just see two or three things.
Let him complete first. Let him complete first.
What
You have filed your counter also. Please tell us the paragraph number.
now in the CRIT proceedings which were going on against SRUIL, he has made a claim. He has given steel to SRUIL for 30 crores. He says that was not paid by SRUIL. Now in the CRIT proceedings, he has made a claim. And the CRIT has accepted 17 crores of his claim of 30 crores and the balance 14 crores has been kept under investigation for more investigation as to whether this is due or not. That is what I am saying is wrong. He says, you give me my money and I will go home. So he's filed this entire petition for his money, which he's got a degree. He's making your lordship into a declarative court to confirm his degree. Now, if your lordship sees Exhibit C of my affidavit, maybe give your lordship a no. This petition is not takeable at all.
I have a
No, I will answer in one word. Only one word, my lord. I went to the NCLT after this petition was filed. There's no question, nothing been not disclosed. Don't make irresponsible statement.
You show us where you did.
No. I went to NCLT for the claim subsequently. Yes. My lord, this petition was filed in 2022.
Yes.
There were no fights. So we filed in 2023. We went to the NCLT much later for the claim.
Lord, here what he did against the 7th February order is final review. That is the order where the High Court, your Lordship, have held that the matter is the auction is to be conducted by the official. Against that, he has filed a review. That review till today is pending. Then on 2nd May 2019, your Lordship have passed another order, against which he filed a review. That review was dismissed. He went to the Supreme Court. That was also dismissed. So on the civil angle, everything was dismissed. On the criminal angle, Lord, an FIR was filed in Bombay. We challenged it in the Bombay High Court. And your Lordship have quashed the FIR. Simultaneously, my Lord, ED took out an ECIR in Delhi. My Lord, that was challenged in the Delhi High Court. That was also rejected. The ECIR was rejected. ED filed an appeal to the Supreme Court. The Supreme Court rejected it, told the ED you comply with your alternative remedies. ED filed again before the judicial magistrate. That was also rejected. So even on the criminal angle, there is a complete quietness and a finality on the whole issue. He himself has stated in grounds L and M that he has exhausted all his alternative remedies. In fact, his remedies are still pending. He has not told your Lordship that he's even gone to the GRT. So he goes to the GRT, he files reviews against your Lordship's order, he goes to the Supreme Court. Supreme Court dismisses it. What remains in this matter? Now he comes and says, I have a decree in 2015, you give me this money and I'll withdraw the decree. This is, and the decree is not against me. The decree is against SRUIL, which was the original builder, to whom he gave 30 lakhs. Now, if he has a claim, he's made that claim. He has a claim. So, in the winding up, he has a right, if he's entitled under 26E or MSCE or whatever it is, he's made his claim. Out of his claim, 17 crores have been accepted, 14 is under investigation. So, what is he coming here to your Lordship?
Forget about the civil aspect. Forget about the civil aspect. Let us deal with the criminal aspect. Forget about the civil aspect. I don't interrupt. Yes.
Lord, I have made a compilation of all the orders that have been passed in this matter.
But just there is a.
Civil aspect.
Yes, I'm just giving it. I'm not. But I did give it because my friends had not told us. What was entered Mr. Chupara and just giving it to us. Sir, no meeting.
Yeah, both of you. It's for both of you to exchange it in the morning so that you can reflect on that.
Your Lordship and last time asked him to file a note and written submission.
All that, all parties will have. There is
You can. I have only a very brief submission to make. I said certain facts about the civil aspect. I am not pressing about that. I am only on the registration of an FIR and investigation of the crime. I am not at all pressing the civil aspect of it. No. That I will answer. You complete it.
And your objection will take note of that.
Yeah, let me. No, then your Lordship, hear me in reply. Yes. No. Yes. Let me complete. I just want to rejoin them. Yes.
Lord, the petitioner has obtained a decree against SRUIL, which is ACIR. But this does not have a seller. It has, Lord, I mentioned it in the note, Lordship's claim with the RP. RP has adjudicated this claim. Under ITC, he is entitled to receive monies under the waterfall mechanism under the decree of ITC. He stands in the aggregates. What he does is, the property prior to the company being going into CR, he was sold by the secured creditor under the SARFAESI Act. This petitioner has filed a section 17 for the DRT. The ON, not in the winding up proceedings, because post sale, there was a winding up proceedings. The ON had filed a report because according to this. So it's a part of my note. Just one thing, I wish to say, just one thing I wish to say. Yes, one thing I want to say. This issue of sale was taken up before in a review. Yes.
I don't expect your lordship to remember anything or except a few words I have to submit now. The civil aspect, forget about it. I made a mistake in making reference to that. Yes. All that my friend says, there is his client has been convicted or acquitted, and therefore there is a matter has come to an end. Now the concept he says, Namo debat bis vexadi pro uno et illam causa. No man shall be vexed on the same question more than once. That or in when it comes to criminal matters, activo is acquit, activo is convict. For this doctrine to apply, there must be a trial. There must be either an acquittal or conviction. So the concept that he is being put in double jeopardy has absolutely no relevance. The concept of recidicate or the concept of estoppel or the concept of nemo debet mis vexadi pro uno et illam causa. No man shall be vexed on the same question more than once. That has absolutely no application. For that principle to apply, assuming that principle is applicable, then my lord, the cause of action should be the same. The parties have to be the same. There must be there must be adjudication on merits. And my lord, secondly, it is said by Ulpian, si omnia sunt tiram. The earlier proceeding should be same in every respect. Si omnia sunt tiram, idem corpus, same corpus, idem quantitas, same quantity, idem just same rights. Idem, one second, don't interrupt. Not interrupt. Or idem causa, let me complete why you interrupt me. Idem causa petendi, it should be about the very same cause. And idem qualitas personarum, idem qualitas personarum. So therefore, the doctor recidicata or nemo debet bis vexari pro uno et idem causa, that no man shall be vexed on the same question more than once to apply. There must be a complete adjudication of facts.
Yes. One second. You are just telling us this Latin and you are not referring to Constitution.
No, therefore, yes, Article 23, no person accused of offence shall be compelled to witness against himself, and secondly, no person shall be subject to very same or prosecuted for the same offence more than once. Yes. Now the question is, let me complete it.
I have only one point to make. If you have
no, let me complete it, my dear friend. Let me complete it. Let me complete it. I am only on that. Let me complete it. Yes. Therefore, from the Dr. Bruce legal maxims.
No, Brooms simply close. Right? Brooms don't open.
No, Doctor?
That is Brooms.
Dr. Bruce legal maxims. Dr. Bruce legal maxims, yes. And in criminal law, nemo debet bis vexari pro uno et idem causa. In criminal law, it is nemo debet bis puneri pro delicto. Yes. One second. But let me complete it. What is the hurry?
My lord, we have not been given time to say.
No, let me.
It's all right. You please give here.
Yes.
Unmute all of you.
Yes. My lord, let me read this paragraph from the Brooms legal maxim. My lord, yes. No, I have not argued. I have not replied. What my friend has is absolutely wrong.
Anything you are repeating?
No, I am not repeating the same thing. My friend is saying there is a earlier statement in a case where I am not a party, and where look at this is absolutely, my lord, I don't use very strong words. Somebody a criminal complaint. Look at the criminal complaint tend to be quashed on the ground that the complainant is of a bad character. And look at the many things I didn't wanted to say. Look at the dates. Petition is filed. Very next day it is taken up. Very next day interim order injunction is granted. Very immediately it is taken out of time and allowed. When people come here and wait for months and years. No. Aspirations. If aspirations have to be. Aspirations have to be embraced. We will do it. We don't fear anybody. We are fearless. There are many things I am not telling. Don't provoke me. I am not telling many things I know here. No. Many things which are happening. Don't think we don't know it. We know it.
You have indicated that on the previous occasion you have read out the full.
Yes.
You have read
And
in full the judgment.
yes, my lord. Now let me say that very peacefully. That judgment was such a horror, and using that judgment, all criminal proceedings against others were also set aside by the Delhi High Court. And then the matter was taken to the Supreme Court by the ED. And then the Supreme Court said ED can act independently. And what ED did, ED went to the very same magistrate at Wada. That magistrate has no jurisdiction. And when the criminal law, lex loci and delicti, where the offence has that court alone has jurisdiction. And somebody was ill-advised that jurisdiction is determined, the determinative factor is the residence of the complainant, and on that misadvice, I know which lawyer advised it. These are things which are known, which we don't say here. He went and lodged a complaint there at the instance of the Sree Ram ill-advised. And when we do it, we know all those things happened. The magistrate was managed. Everything is true. Everything, but that does not protect him and cannot protect him. If I say something more, my lord, it will be very palatable. That was a judgment. That was a judgment which was obtained by my lord. I am not completing my sentence.
Repeating all this.
Yes, and therefore the ED made another mistake. Instead of going to the may I take your lordship to the order, the order of the magistrate. It is produced along with the reply. It is replied. And the Supreme Court in his judgment said, one second, my lord.
Please come and see.
One minute. Three. Okay.
I think in a court like this, everyone.
Remove the structure you ran with
They can't.
10 minutes. I will only take 10 minutes and in measured words. The papers run to thousands of pages. But the controversy is very simple. They abuse the SARFAESI Act to conduct a fraud of an auction. Indiabulls finance installed shell company, provided the funds, and the same day the money was transferred back. That is the chart shows, very same day. What is the chart? The chart. Again, take your lordship 1 second for the lordship's precious time. On 24th and 25th, the money was from Indiabulls real estate was transferred to Ashton Township and Ashton Developers, and the money went to the owner shelters. Owner shelters purchased the property from Indiabulls House and Finance, which has sold the property under the SARFAESI Act. On the very same day, the next page of the chart, the money was transferred back. It amounts to an offence of money laundering, and this needs to be investigated. And the other fact that the company has only 1 lakh capital, no revenue, no transaction, nothing. And the only counter contention is, in some other case, on some other complaint, came to be quashed by this court. And it has no legs to stand because the parties in that complaint is different. The controversy was different. It has nothing to do with the lending of the action of the SARFAESI Act. That was about the directors of the company manipulating the share market, making money, and siphoning of the funds to overseas. That was an entirely different issue. I am not doubling your lordship by taking a lordship to the judgment and another one, because that is not a dispute. To save time, the issue which came to be discussed in the earlier petition before the Delhi High Court and before this court was an entirely different issue. So the cause of action is different, parties are different, and there is no investigation even. So they were trying to import the doctrine of estoppel, nemo debet bis vexari pro uno et idem cosa. No man shall be vexed on the same question more than once. That primarily belongs to the realm of civil law, judicata. And the reason is, the purpose is different. The purpose in judicata is in the resto republico ut sit finit litium. It is in the interest of the republic that there shall be finality of litigation. The criminal law exists for another purpose, to protect the interest of the public. For every offense, every crime is against the peace of the king and against the public. So these concepts have no relevance at all. And because I don't wanted to bring the doctrine of, because they in the counter they have taken so many pages referring to Interesto Republico ut sit finit litium. They refer to, yes, I'm reading that, they are affidavit only. Judicata pro veritate accipit, I am reading from your affidavit only. And paragraph 4 started. It is submitted that the doctor Interesto Republico ut sit finit litium. These maxims are yes. No, this is the counter of
that paragraph 4 we have noted.
Yes. Now
you said that you want to cite some judgment.
No. All that, my lord, they thought of taxing your lordships. Time is what stands in the way, even from reading out, my lord, proves legal maxim. Only one page only, my lord. And that your lordship permitted, yes. 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 My lord, there are two, three beautiful books. Everest on estoppel, Casperus on estoppel, Handler on estoppel, and Bigelow on estoppel. So that, my lord, but I did not take any of those things. I took what was readily available and was the briefest one. At paragraph criminal law.
Read everything again, Pada. You have to read everything again. Rest assured. We will read everything, every word.
Yeah, my lord, is it, my lord, your lordship's burden is so much of brief and so heavy bundles. I never came to Bombay only saw this big bundles. In Kerala High Court, our petitions are 2-page, 3-page maximum. Yes. Now coming to that, my lord. Then
you have.
I have only two more aspects.
We have heard you.
Only two aspects, only 2 sentences more. Then, based on this judgment of the Bombay High Court, holding that the complainant was a man of unworthy character, Delhi High Court set aside everything, even against people who are not parties to that. Then, my lord, the Supreme Court, my lord, to an extent, set aside that order. I take your lordship to only very brief only, page 937 of the counter affidavit, page 937. At page 939 and page 939. I will skip reading, my lord, only a little bit I will read it. Page 939, paragraph 15, minute part. Minute part. The appellate ED can, your lordship got, my lord? Page 15.
You read it last time, just see the pencil.
Yes. ED, yes, your lordship. If the ED can invoke, they can go to the magistrate, they can act independently. Yes. The ED can resort to independent proceedings such as approaching the judicial magistrate under section 153, etc. I am not reading further. Now, the ED went to the magistrate. The ED made the very same mistake. They went to the Vada magistrate who has no jurisdiction. And that Vada magistrate, where is that order? Yes. That Vada, yes, it is that page. At page 943, only I take 1 second only, my lord. Only 1 second. Page 943. Next page, 943. Your lordship got page 943. I already read only 2-3 sentences only. This application filed by the officer of the Director of Enforcement, etc., under etc., and was reading. Then the magistrate come to a conclusion that yes, at paragraph 947. Now, turning to the facts of the present case, admittedly there is nothing on record. The applicant approached the police station in view of the section 173 of the Bharatiya, etc. Admittedly, the present application is based on the facts mentioned in the FIR, which is cashed by the Honorable Bombay High Court. While quashing the FIR, the Bombay High Court had observed that no part of the transaction is shown to have been undertaken within the jurisdiction of this court. So the Vada magistrate only said, I don't have a jurisdiction. And magistrate is completely right. And all that, I'm not saying that they should be convicted. They should have all the rights what the Constitution and the law provide, including Article 23. But there shall be an investigation. That's all, my lord.
Right. So,
I don't want to repeat, but he's gone to the Supreme Court. Supreme Court has dismissed it.
that you have said, sir.
The sale has been approved by the Supreme Court because the RP filed an application before the Supreme Court and the Supreme Court has approved the sale.
So we'll consider that all your counters.
And there's no question of any criminal. If my learned friend wanted, he has not filed an appeal against your lordship's order dismissing the FIR. He has not filed any appeal against the Delhi High Court order dismissing the ECI. So nothing remains. What criminal action is he talking about?
He has some other argument.
Because I'm respondent number 36. Because I'm an individual, I'm not a company. Because in his complaint which he filed at Exhibit N, which is at 2022, because he does not make me a party to that. For the first time I made a party to this said petition, and not a whisper against me.
You are respondent number?
36. Not a whisper against me of any role, any complaint. And in my affidavit, it starts at page 824. Your lordship would only mark para 4 at page 825, where I've categorically stated that I have no connection
That is
whatsoever.
not his contention. His contention is
That's
everyone may not be roped in FIR.
That's
That is a matter for investigation.
that's
Even if some more persons have been named, this is also a matter for investigation, and on conclusion of investigation, the investigating officer may choose to delete them, to file charge sheet, not to file charge sheet. What he is saying that let there be an investigation. That is whole prayer in this petition. That's all. Registration and investigation. You give your appearances. That's all.
Only 2 points which have not been done. In short, the points are this: that my lord, whatever was argued was in respect of an action under SARFAESI, which my lord was under the supervision of this honorable court, my lord, taken right up to the Supreme Court. So what has not been pointed out in detail is the fact that before filing this petition, my learned friend, client, my lord, had elected to file a review petition making exactly the same allegations made in this writ petition. Therefore, the doctrine of my lord choosing his remedies will come into play. If I may just point out to your lordship, page 150H of the petition is an interim application filed by him. Second point is, my lord, right from the decision of Sree Vasu till today, consistent view of the Honorable Supreme Court is that the power under 226 should not be exercised to direct registration of an FIR when there are alternate remedies. My lord, I'll cut it short, a small note, 1 page, 2 text.
My lord,
Order a registration of a first information report for investigation. First, opposing this petition, Mr. Shroff, the learned senior counsel appearing for Indiabulls Housing Finance, raised several objections, including suppression of material facts. The learned senior counsel contended that the issues which stand concluded by the decisions of competent courts cannot be agitated and reopened in a petition like this filed under Article 226. In edit proceedings, only simply that in edit proceedings, the learned senior counsel stated that in the proceedings of CRIP, the petitioner made claims for rupees 30 crores and his claim for 17 crores has been accepted, whereas 13 crores, claim for 13 crores is under investigation. The learned senior counsel referred to the grounds L and M as urged in this writ petition and further indicated that the petitioner approached different other forums like DRT and information with respect to which has not been disclosed in the writ petition. Full stop. The learned counsel appearing for the respondent number, you can simply put 36, stated that there was no whisper about the respondent number so and so in the complaint made by the petitioner, and it is for the first time that it has been made a party respondent in the petition, and that too without. Is there any allegation against you or not in the petition?
No allegation.
Without any allegation in the petition. The learned counsel appearing for the respondent numbers 12 and 13 raised an issue in law as to jurisdiction of this court to issue direction to the investigating officer to register a first information report. Why Sakhi versus so and so. Please give the citation.
Yes.
The learned counsel has also referred to page number so and so to demonstrate that on identical facts a review petition was filed by the petitioner. The learned counsels appearing for the appearing parties have made their respective services. You take this flow chart taken on record. Judgment reserve. You can give. There is no need. You have filed your counter affidavits.
Lord, we've also filed a very short note.
Given no necessity. We have recorded in length your arguments.
Lord,
Almost everything. And there are notes, and so we'll incorporate in the judgment. We'll take note of everything.
My learned friend Mr. Khandeparkar had also addressed your lordship on behalf of honest shelter. He is also tendered. Lord.
My lord.
No, my lord, when your lordship may note two things, the parties are different. Cause of action are that's parties are different. This issue has never been under came for consideration anywhere. Yes. And the issue into the DRT and all was about the civil nature.